Hello, everybody. This presentation is an overview aimed for parents and caregivers of young adult ages 18 and up. Understanding conservatorship. We are supporting transition age youth with intellectual or developmental disabilities. My name is Elvia Diaz, and I work as a family transition specialist for navigating change at San Diego State University. And I am also a mother of a 20-year-old son with autism. This presentation is aimed to help you understand what conservatorship is, learn when conservatorship may be appropriate, explore alternatives before pursuing conservatorship, understand the legal process in California, learn responsibilities of conservators, and understand long-term implications. And of course, we're going to identify resources and next steps. It is important to mention that the terminology that we're using is valid in California. In other states, may be called guardianships or even in other countries. So the terminology used here is valid in California. So what happens at the age of 18? Well, your little giant has reached the age where they are legally responsible for all their actions and decisions. We know that they may not be emotionally or intellectually ready, but before the state, they are liable. I'd like you to think and consider this example. There's this little girl. She's 19 years old, and I say girl because intellectually and emotionally, she may be 11 or 12 years old. But she has an asthma attack and needed to be taken to the hospital. And the parents did not know that she had been consuming marijuana. So the girl is unconscious, and the parents are desperate for not being able to help their daughter due to the lack of the legal documentation they need. Can you imagine that? This is a real scenario. So what happens when our youth turn into age 18 years old? Well, they have the right to make medical decisions, sign contracts, manage finances, decide where to live, access educational records, and of course, consent to different services. So what is a conservatorship? Well, conservatorship is a legal arrangement where a judge appoints someone to help an adult who cannot safely manage certain personal or financial decisions independently. The person receiving support is called the conservatee. The person appointed by the court is called the conservator. And in California, conservatorships are handled through probate courts. As mentioned before, we are not going to confuse this with guardianship. For the purpose of this video, we're only talking about conservatorship. So is a conservatorship necessary? Well, we have to consider that sometimes, in my case, my son turned 23 years old, and I will mention why, but I had to decide whether finally I needed to start doing a conservatorship. So each family is different. In my case, we started getting credit cards, and we have to really decide what certain rights they need to keep. So it should only be considered when it's less restrictive, and of course, what the other alternatives are not enough. We're going to talk about those alternatives in a minute. So, of course, the goal is always to support independence whenever possible. So what are the alternatives to conservatorship? Well, one is support decision-making. On another video, we're going to describe each of these. Right now, we just want to mention them. And these alternatives are supporting decision-making, education consent forms, advanced healthcare directive, joint bank accounts or HIPAA medical release forms, which is important to mention that this HIPAA stands for Health Insurance Portability and Accountability Act. The HIPAA allows providers to share medical information with authorized individuals. So the HIPAA is different from a medical power of attorney because we have this, and this is on red. Durable power of attorney is a must. As I mentioned, I decided to wait to decide whether I needed to have a conservatorship or not. But when my son turned 18, the very next day, we were signing the durable power of attorney because you don't want to risk that any of situations you will not be able to help your loved one. So don't wait. My recommendation is do not wait until you are granted the conservatorship to be able to help your loved one, because it is very important. So in some parts, the power of durable power of attorney, it's enough. But depending on the insurance, you may also need to have the HIPAA, the Health Insurance Portability Act and Accountability Act. So you need to ask your insurance. But once your loved one turns 18, my recommendation is, and I cannot emphasize this enough, get a durable power of attorney. And I want to emphasize also that you need to just maybe be the representative, pay Social Security income. But remember, you're only a representative. You are not to have a joint account. That is very important to have. So what are the types of conservatorship? Well, there's limited conservatorship, which is basically designed for adults with developmental disabilities, and general probate conservatorship. That means that is usually for adults unable to care for themselves due to serious impairment. So what are the rights? Well, the conservative may lose the rights related to medical consent, voting in some cases, choosing residence, financial control, marriage, relationships, and contracts. So remember that the courts are encouraged to preserve as many rights as possible. So again, in another video, we will explain each of these rights. So what to do? If you decide that you will go through this process, it is very important that you speak to the regional center service coordinator, because you need to discuss the other alternatives with them and gather evaluations and records, medical records, and they will legal society will give you the proper forms. And of course, you need to together identify what support needs and clearly what your loved one needs. And then you need to decide who will serve as conservator, because remember, part of the procedure, you need to be approved. And so you need, sometimes there's a conservator and there's a conservator. There can be more than one conservator. So you need to decide all that. And the regional center report is required before a limited conservatorship here in California. So it is very important that you get your service coordinator on board. And of course, please, very important, contact your legal aid society because they are very helpful. So what is the role of the regional center? Again, the family should contact their service coordinator early. Before you start doing anything, contact them. And then they are going to evaluate the individual's needs, and they're going to provide recommendations to you. And then later, it will be the same recommendations to the court. And then they are going to also help you assess whether conservatorship is appropriate, and they help determine which powers are necessary. Because remember, they have the case. So here I want to mention something very important, because there is emotional considerations for family. This is a very important step, and it can be very emotional and difficult sometimes to decide. See, because sometimes parents may often experience fear or guilt or uncertainty, and of course, stress about the future. There are some considerations like family dynamics, who is really going to be trusted with this very important decision. Sometimes parents are separated and they need to make decisions together. And it is important to include the young adult in the discussion. This is a must. You must include your loved one into the decision because, as we'll mention later, he must accept to be conserved. If he doesn't accept to be conserved, you don't need to go through the process because even though he may need it, if they don't accept it, they are not going to be granted. So you're going to, of course, focus on empowerment and balance the protection with autonomy. So we would like to suggest these questions. What decisions can your young one already make safely? What supports are already working? What risks truly exist? Could limited powers be enough, maybe? Or have we explored all the alternatives first? Like I mentioned before, since I had the dual power of attorney, I decided to wait. And then, well, I realized that my son had reached a threshold. And not just credit cards started being offered, but he was offered to work in a contract that was to his disadvantage. And each case is different. But so we just want to protect our loved one. So once you decide that you want to start the process, you need to realize that the petition includes different court forms, confidential information, requested powers, and relative information. And then it is important that you decide which powers you want because you want to avoid requesting unnecessary powers because they may be denied and then take longer. And of course, be very specific and consistent. You cannot say one thing here and another thing in another form. Now, the notification requests, the court requires notification of parents about siblings, close relatives, and interested parties. This is very important because you are going to give a list of the most important relatives. By that, if you are a single parent, well, you need to notify the other parent, and you need to notify the grandparents and the siblings. So they must be notified that this is happening. And this is called due diligence. And the court wants to ensure transparency and protect the rights of the conservatee. Again, I want to emphasize you need to contact Legal Aid Society and they will provide with the forms that you need. So the court investigator is the interview, the conservatee, and the family. And of course, the probate examiner reviews paperwork and accuracy and legal compliances. So all the documentation is reviewed and they may come unannounced and visit your home to see how you live and how you're taking care of your loved one. The judge makes the final decision and again, emphasis. The focus is always the best interest of the conservatee. So once the judge reviews the reports and this testimony and the requested powers they granted, and then the proposed conservatee has the right to attend, object, and have legal representation. So again, you must talk to your loved one that they must agree to be conserved. Or if not, there's going to be a different legal route. But if I know families that they have gone through the process, and then once they were there, the young one was not informed properly, and they decided to reject being conserved, and everything just went down the hill. And even though, of course, they really needed it, but since he looked like he didn't need support, and then the judge just said, oh, fine. So the judge may grant, modify, or just deny the request. So you need to really be aware that your young one must understand the implications and consent to be conserved. So once you have been granted a conservatorship, you need to, the conservators must file reports, and then you need to notify the court of maybe your address changes and maintain records and act in the conservatory's best interest. The probate conservatorship generally do not expire automatically. So there is no set time. So, but usually it is said that it can last even up to a year. And well, we don't have information about the cost, but I know that there are waivers that you can request. So the responsibility of the conservators is you must respect the conservative's dignity, you must encourage independence, and you must make decisions carefully. Of course, avoid any conflict of interest, keep accurate records, and follow the court orders at all times. So the most important key takeaways is the conservatorship is a major legal step designed for protection. It is not always necessary, and we want to use the least restrictive option to still provide safety and support for all loved ones. So we recommend that you use these resources and support. Of course, the San Diego Regional Center, the California Court Conservatorship Information, Judicial Council of California Forms, Disability Rights in California, and Legal Aid Society of San Diego in this case, but there are other legal aid societies in different counties. So for the resources, we would like to mention that you can have the forms and the Disability Rights of California, and there is a webinar that you can watch if you want more information. Thank you very much for watching, and we recommend that you contact legal aid. But if you want more information, we're happy to help you. Thank you for being here.